Hi, everyone. Welcome. Welcome to the launch of the Serpentine's first Legal Lab report on issues that arise in art and tech science collaborations. My name is Victoria Vanova, and I'm part of the Serpentine's Arts Technologies team. So here to my right, we've got Alana Kushnir, who's the principal investigator of the Legal Lab and also lawyer, curator, and founder of Guestwork Agency. That's it. An art law and advisory firm based in Australia but operating internationally. And here to my left, this is slightly artificial, apologies for that. We've got Marie Patel-Saville, who's lawyer and founder of Amarabi, a legal innovation by design agency based in Paris and also operating internationally. Marie is amongst a distinguished group of advisors to the Legal Lab, and we're incredibly thankful to Marie and her colleagues at Amarabi for supporting the production of this report. I'd like to personally thank Elizabeth Talbaudet, Antoine Moutier, Juliette Nier, and Mathilde de Rocher, who are all part of the expanded Amarabi team, for their endless hours producing this report. So, there were quite a few people who were part of this process, and it is incredibly important for us to ensure that all of them are thanked here, but also perhaps for you to appreciate how kind of expansive and networked both the research and the production processes have been. So I'd like to thank Astrid Kohlmeier, who is also part of the Legal Lab advisory panel. She's a lawyer and designer working in legal design and legal tech. Let me just scroll down. And she's been really helpful in helping us structure and really kind of choose our research methodologies in which ultimately kind of shape the final findings. We're also very grateful to all the other advisory panelists, so Connell Parsley, Daniel McLean, Evila Getov, James Refford, Kathleen E. Keem, Lauren van Haftenschiek, Rita Rigo, Sarah Raymond, Sophie Netchaev, Yayor Shionyori, Safia Ahmed, and Roxanne Peters. Now, we had the honor of being helped by Katie Beale and Estella Oliva in spreading the word about the Legal Lab survey campaign. That was a really important part of the research process. And so we're very thankful for them for helping us with that campaign. And of course, to all the respondents who took the time to fill in the long-form survey, to respond to the short-form surveys, and to also take part in our in-depth interviews. Law isn't really something that we talk about with, let's say, a lot of ease, particularly in the art field. So it has been incredibly generous of all of you who filled out that long survey to share your views, your perspectives, and ultimately the reason that we have this report is thanks to you. So thank you if you're in the audience, and please say hi in the chat. Now, of course, none of this work would have been possible without the larger Serpentine Arts Technologies team. So thank you, as always, to Kay Watson, Eva Yeager, Tamar Clark-Brown, and of course, for the producers, to the producers of this event, who are just right here. You can't see them, but I can. Alex Boyce and Ralph Pritchard. And of course, many thanks to Karen Green for providing the BSL interpretation. We've also had a number of research associates who've been kind enough to extend their time to this endeavor. So thank you, Adelaide Dunn, David Yanal, Philippa Griffin, and Jasper Salamonch. And last but not least, Serpentine is also grateful for the ongoing support of Arts Council England, VILE, and ACOM. So now we can get to the meat of it, hopefully. What is the Legal Lab, and what is the mission of the Legal Lab? So the Legal Lab was founded in 2019 as an R&D space focused on advancing the role of legal infrastructures that are critical for supporting art and tech science collaborations, particularly given that these collaborations are gaining increasingly more systemic presence in contemporary culture, where artists collaborate with technologists, scientists, tech companies, and research organizations, and where art institutions often take the role of intermediaries. So with Alana as principal investigator, we launched a series of, or we instigated a series of exploratory trajectories, which culminated in a summit on 1st of October 2019. And that summit brought together artists, technologists, art institutional representatives, lawyers, and critically legal designers. We're incredibly thankful to the participants of that original summit, as it really set the direction for the research that has been consolidated in this report. During the summit, what became evident is that there was a big gap between, on the one hand, the excitement and appetite for art and tech science collaborations, and on the other hand, kind of a lack of a common understanding of how these collaborations should be dealt with from the perspective of highly consequential legal details. So the research that followed that summit was very much trying to get to grips with the perspectives, assumptions, and expectations that different parties to these collaborations bring with them. And by the way, Adelaide Dunn, our research associate, has produced a very succinct report on the summit. So if you're interested to see where kind of the story started, so to speak, you may access it on the Legal Labs page on the Serpentine website. And of course, this event would not be true to purpose if we did not mention that the content shared and discussed here today is of general nature only. So if you require legal assistance or legal advice, please do consult a lawyer. If you don't know any lawyers specializing in art and tech, please do get in touch with us on legallab@serpentinegalleries.org. Perhaps, Alex, you can leave that email in the chat, and we'd be happy to point you in the right direction. And yes, on a practical note, please feel free to pop in your comments and questions into the chat, and we'll try to address as many of those as possible towards the end of this discussion. So without further ado, I'd like to start by asking Alana to tell us about her journey into art and law and how the lab fits into the more general rubric of various art and law initiatives that have been happening across the decades. So please.
Sure. Well, thank you so much, Victoria, and the entire Serpentine team for hosting this event today. It's been an absolute pleasure to work with you all over the last couple of years. It's an incredible opportunity, and I'm grateful every day for being able to work on this very exciting project. But a little bit more about myself and how I got to doing this work, I guess. I've always been extremely passionate about art and law. And I think, for many of my years, I should just say my professional career as such, so, almost 20 years now, I've always sort of bounced back between working in the arts, working in the law, working in the arts, and not really finding that I was completely comfortable in one of those arenas. I really felt like I was comfortable somewhere in the middle of these disciplines. And I think that's something that really resonated me with the conception of the Legal Lab. It's not strictly a project for the art industry. It's not strictly a project for the law industry. And I think, kind of recognize that the future for these various fields actually lies somewhere in between. There are also a number of really incredible art law initiatives that have existed for a number of years and have been very influential in how we develop this project as well. We've been honoured to be able to work with them on a number of projects to date. Those include, for example, the Centre for Art Law, led by Irina Tarsis. They provide incredible opportunities for individuals with an interest in art and law to learn more about how the disciplines intersect and to educate artists in particular. Also, the Art Law Foundation in Switzerland, as well as the Institute of Art and Law in the UK. So, there are these projects that have existed which have looked at that intersection. There are also projects that are more, I guess, conceptually oriented when it comes to the intersection of art and law. Most of those have been generated by artists and curators. And of course, the one that springs to my mind, and perhaps to you, if you are familiar with this art and law area, is the Seth Sieglau and Bob Brzezinski contract. And if you're interested in learning about that contract and why it's so important, one of our research associates for the Legal Lab, David Ienel, he wrote an excellent research paper on the history of how artists have engaged with art and law, and including this contract as well. And again, you can find a copy of that paper on the downloads section of the Legal Lab page. But so I guess what I'm trying to say is, on the one hand, you have these fantastic initiatives that are focused on, educating the public around art law issues at a very kind of practical level. At the same time, you have this kind of more conceptually oriented art projects as well, primarily led by artists and curators. I think what we've been trying to do with the Legal Lab is a little bit of a different focus, maybe a little bit from both, plucking from both sides of the tree, so to speak. So, firstly, kind of identifying and really, I'd say an important part is making public the issues that collaborators face when they're working on projects across art, tech, and science. Because what we have found is that, a lot of these legal issues, when they play out in practice, it's very hard to learn from them unless they are, go to court and a judgment is handed down. A lot of these disputes around, these legal disputes, they result out of court, where the parties are generally required to keep quiet about what they've agreed to. So it's very hard for others to learn from their experiences. So yeah, so a big aim for us is in making public some of the legal issues that individuals and organisations are facing in this space. And also, secondly, and I guess that's what we're heading into now, since the launch of the Legal Lab report, is the kind of the second phase of the project, or maybe it's the third phase really, is prototyping solutions solutions to these issues, and using design-led thinking as well. The design, I should say, the design-led approach to thinking about law is something that we've been very inspired by. So sorry, that was a bit of a roundabout way of answering your question.
No, thank you so much. I think that's very useful to sort of understand about your background, but to also have a bit of an overview as to what art and law as a sort of ecosystem, what that has been like historically. And, I guess what's implicit in what you're saying is that ultimately, historically, it's been a bit of a fraught relationship. So there are some organizations that focus on these questions kind of from a sort of, I guess, more general knowledge perspective, and then from a more conceptual perspective, that's the artistic side of things. But ultimately, it has been a fraught relationship. And when it comes to kind of systemic utilization of the law as a sort of tool of empowerment, that hasn't really fully happened within the art field. On the contrary, there's a bit of a suspicion around the law. And that, of course, isn't, the art field is not the only field that has that kind of relationship to the law. And in part, that has maybe something to do with the fact that there are barriers to accessing legal advice and support more generally. And self-education is also quite challenging, right, when it comes to the law. So this is actually one of the reasons why we look to legal design, right, as a possible bridge to providing this sort of interface to law that could make it more accessible. So with this, a question to Marie, what is legal design? How did you get into it? And can you provide some examples as to the areas in which it is being utilized?
Thanks a lot, Victoria. Well, first of all, let me say that I'm very happy to be here with you, and it's been a real pleasure collaborating with you and Alana and the Serpentine at large over these past nearly 2 years. I'm ashamed to say, almost, but it's been an absolute pleasure. What is legal design? Well, it's nothing else than the mobilization of design in the legal area to make legal documents and legal processes much more accessible, actionable, and engaging. You've said it very well, Victoria, and Alana as well. It can be a sort of forced relationship between law and its users, basically. We know that this relationship is not going very well, and it's been so for a number of decades. So our goal really is to bridge the gap between the law and all its users, And the way we're doing this is through user centricity. The starting point should be the users. So we define them, we define their user journeys, we define their needs, expectations, their friction points, and we solve all these pain points through the new version of the legal document we're working on. So this is really the key to accessibility. As to how I came into to doing legal design, very basically, what Alana shared earlier resonated also with me, because I guess I always felt a bit misplaced when I was in private practice. I was a private practice lawyer for about 10 years at Freshfields and Allen & Overy. It was intellectually very stimulating, but I didn't exactly feel at home. I guess what was lacking in my practice was precisely accessibility. So when I moved in-house, this lack of usability of the law, was even more striking than when I was in private practice. And so I decided to do something about it. So I just tried. I tried several different methodologies. I tried lean, agile, many different methodologies until I discovered something called legal design in the legal design lab led by Margaret Hagan at Stanford. And it sounded so promising that I thought I should give it a try. So I did that. I started a first project in my own legal division, which was a success. So I did a second one and then a third one. And at some point, on the one hand, my internal clients were so positive about it. The feedback of the business was so positive that I thought I was onto something. And on the other hand, I was so satisfied with my own professional practice this way that I just didn't want to practice law in any other way. I just couldn't stop. So I had to launch my own agency, which I did about 3 years ago. And about the examples of where legal design can be applied. Well, it's really like design in general. There is no specific field where design should be applied or not. It's just a matter of solving as many users' pain points as possible. But in practical terms, we could say that legal design could be applied to terms and conditions. For example, we worked for a very well-known art gallery, which we cannot name, but they're working internationally, and they came to us because the novice buyers had some difficulties understanding how the art world works, basically the art fairs, how you purchase a piece of art and how you cannot change your mind afterwards because you don't like the color, for example. So all of these required a mediation, some accessibility, which we tried to do in this example that you can see on screen. And perhaps just another very recent example, we are currently redesigning privacy policies for teenagers in the video game industry. It happens that teenagers and children have the same personal data rights than adults. It's just that obviously they won't read this horrible wall of text that is usually in lieu of privacy policies. So we are trying to change that.
Great, fantastic. Well, thank you so much for founding Hammurabi and for agreeing to take us on as well in the beginning of your journey. So, Alana, then how did legal design factor into the research of our report?
Well, I think, it was an interesting coincidence of timing, I should say, because when we started the legal lab, so what was that, back in very early 2019, that was around the time when legal design started to get a bit more of an uptake. And I think, at that point in time, I also probably befriended Marie on LinkedIn and a couple of other legal designers as well. And I found that, the conversations that were happening on LinkedIn were quite interesting in that space, very new and very fresh. What I also found interesting at that point is that, here we have this kind of movement to revolutionize the way in which the law is done, the way in which access to justice is done. A movement that, you know, relies on these kind of very creative ways of thinking and communicating. And yet when it came to the art world and the way that law was being, I guess, practiced in the art world, there was kind of the zero presence of legal design thinking or the application of legal design. So that's why it became really important to us, I think, to kind of present in our research, to really incorporate legal design methodology into our report, because it's just something that, I found that at least in the art field, it really hadn't resonated yet. So that's sort of how we broke into legal design ourselves, I should say. But yeah, very much, and we're inspired by Marie's work and Astrid's work and Margaret Hagan's work as well, and the Stanford Design Lab as well. And yeah, it really sort of, I don't know, legal design gave us this kind of toolbox to use, you know, and it kind of gave us more of a useful path to follow when we were trying to develop our focus and how we were going to conduct the research we wanted to do. So, I mean, when it came to the first Legal Lab report, there's a couple of, you know, I'd say key elements of the report, key aspects that really are heavily influenced by legal design thinking, and especially under the mentorship of Marie and Astrid Kollmeyer as well. But this idea of identifying pain points, also looking at our, we had survey participants, we had interviewees, looking at them as sort of users and breaking down the different individuals and organizations that we were conducting research with as different user types. And this is the kind of, these are the kind of methods that haven't really been done yet when it came to legal issues in the art field in particular. So I mean, different concepts like, yes, as I mentioned, users, user types, pain points. We also conducted a number of different types of research for the report. So as I mentioned, we conducted a survey. We had over 250 responses. It was quite an in-depth survey with a mixture of, I'd say, kind of quantitative and qualitative type questions. For example, there were questions like, when you enter contracts, do you have anything in writing? Or, what are the challenges you have faced when you've entered into contracts before? Questions like that. We also conducted a series of interviews with a range of different user types. So everyone from artists, technologists, scientists, curators, universities, academics at universities, lawyers as well, art lawyers in particular, and technology companies as well. And so we had more focused type of more individualized questions for our interviewees as well. And so actually something that which was very new to me, and, I really credit Marie for this, is really trying to have questions that were more open-ended as part of our research as well. I think as a lawyer, you're very much trained to ask closed questions as such, so very direct and closed questions. So this was an excellent learning curve for me as well. And it's also meant that I guess, and this is also a key point of difference, that we didn't know where we were going to end up or what we wanted to find at the end of our research, which I think is quite different to a lot of other research methodologies where you sort of have to set out with an agenda or a contention from day one. We sort of wanted to develop that as we went as well. So that's a kind of a sum up of how legal design came to be a part of the Legal Lab. Yeah.
Okay, great. I mean, Marie, are there any kind of specific legal design methodologies that are kind of worth talking about? And, when you first became acquainted with our project, did it fit a particular type of methodology that would be very helpful here. So like, how did you work with the material that we presented you with after the research has been conducted, or actually as the research was being conducted, because it was very much a back and forth process. Yeah.
Exactly. Yes, the key to legal design is really user centricity. So everything that Alana has just explained about defining users, all these stakeholders in art, tech, and science collaborations, but it's also about clearly identifying their user journey. So that's a very classic design methodology. This is design thinking, just applied to a specific area. But user journeys are very, very important in legal design, because that's how you can analyze all the friction points, everything that's too complicated, everything that takes too long, that is irritating, that is frustrating, everything that does not work, really. And this is very, very new for lawyers to try to understand what's not working. They rather try to have clear-cut answers and, that's it. So the methodology of user centricity is absolutely core to everything we do. And I think it was particularly helpful here because, as you said, we came in as research was already being conducted. And one of the key strengths of legal design is co-creation with users. And this is why we took advantage of the first summit, which was organized. It was back in 2019. I'm completely losing track of times.
But, you're not the only one.
Exactly. So during the first summit, it was perfect to have all these various stakeholders, artists, designers, developers, art institutions, all together in one room. And we managed to create small workshops and to make them work on given exercises, to start co-creating a number of potential solutions. It was just the beginning, but I think it was very relevant to what the Serpentine wanted to achieve with this legal lab.
Okay, yeah, absolutely. So let's then get to the findings. So some of the findings were not exactly surprising, as there is ample anecdotal evidence attesting to the art field's kind of anti-contract mindset, lack of access to specialist advice, and infrequent use of written contracts. But Alana, were there any findings that surprised you in particular?
Yeah, I mean, I'd say, look, like you say, there were a couple of, I guess, expected responses, especially around, for example, the kind of aversion to contracts that a lot of non-lawyers can have. Perhaps it's not so specific to the art, tech, and science collaborative space, though. Maybe there's more of a systemic problem, as Marie has alluded to as well. But I guess something quite particular that I noticed is in our survey, one of the questions we had was, what type of a business entity, a legal entity are you? And we had, it was kind of like a multiple choice style survey question. So we had, for example, one response could be you're a sole trader. Another response was you were a kind of a partnership. Another response was you're an incorporated entity, a not-for-profit incorporated entity. Also we included the option of unknown. And I think what really surprised me was that it's quite a significant number of respondents who didn't know what kind of a, I guess, entity they were in the eyes of the law for the purposes of, their legal relationships, their contracts, their arrangements, even for their tax purposes. Like, a lot of people just didn't know what kind of a legal entity they were. And I think for me, that's quite concerning, because when it comes to at least, contracts, at the very fundamental level, it's really important to understand who has the right to enter into contracts and what they have the right to do with those contracts, and who has the right also not just to enter contracts, but also, at the end of the day, enforce them if they need to. So, if you enter into an arrangement with somebody and that other person doesn't do what was originally agreed to under the contract, you want to be able to perhaps enforce your contract in a court of law for the court to remedy that. But they're not going to recognize that contract unless you're a legal entity and recognize you as being the one who's, been, who has been at some kind of loss unless you're a recognized legal entity. So, yeah, I think that was quite an important point for me. Also, just this kind of, I guess, perhaps, and this came through more in the interviews, more of a kind of a lack of understanding of what incorporation does, how setting up a company can actually be very beneficial for artists. So I think, when we think of companies, we think of, the mega corporations. They tend to get a really bad rap. This kind of idea that, they exist to shirk responsibility, that they are only out there to make money and to rip people off. Of course, to a degree, that is the case for a lot of the mega corporates, but it still doesn't mean that the actual structures that the law provides can't be utilized by artists and curators and technologists and scientists in ways that are perhaps more beneficial to them than, maybe just that sole trader type of entity where you're unincorporated, where, you're personally exposed to, you're personally putting yourself at risk in whatever sort of, projects you're working on. And I think that's probably something I think would be worth the Legal Lab exploring in the future. This kind of question of what kind of structures might be more suitable or appropriate for these collaborative type projects. Something that could perhaps shift that balance of power, or perhaps balance that power out between the different collaborators on a project.
Absolutely. And there's also a question about longevity of projects there as well, right? So the more these projects kind of attain a longer term character where there's like iterative development and, different phases of the project, the better it is to think, kind of in a more long-term way about the legal structures that are supporting that. So yes, that's definitely a pain point that we'll try to attend to, but there were plenty more pain points, right, that are specific to art and tech. And so the question to you, Alana, I guess, what gives them that specificity? Because we also identify in the report that some of the pain points, they relate to art and law more generally, whereas there are certain pain points that are specific to art and tech. So what gives them that specificity? And what are the wants and needs that kind of arise out of these pain points?
Yeah, absolutely. Well, I think one of the specificities of, the pain points that arise in art tech and art and science collaborations is the fact that more often than not, you have collaborators coming together from many different fields and many different systems of operating and communicating with one another. And so, one of the pain points that we identified was this kind of lack of a common language. And actually, that identification of that pain point was quite an interesting process. Again, very much indebted to the Amarabi team for this. And Marie worked with Mathilde Rocha, who's a neuroscience expert. And once we had closed the surveys and we finished our interviews, what Mathilde very kindly and ingeniously did was conduct this data mining process of all of our user responses. And so part of that process involved picking up the frequencies that different terms are used and looking at when words were used together more often. And so some of the key terms that were identified here was, in terms of pain points, was communication, and time. And also, there were certain common terms that certain user types had. So for example, artists and technologists, I should say, very much this kind of concern around communication, whereas, you'd have like organizations, arts organizations or university bodies really focusing or having concerns around issues like budgets and funding. So I'd definitely say that finding a common language is definitely a challenge and something we'd really like to work on to overcome as well. And I think that also very much comes down to not just a kind of a language aspect or a culture, working culture aspect, but also, the different, collaborators who come from different fields often have different motivations for collaborating. And so that influences how collaborations actually develop, and the expectations that people have when they participate in collaborations as well. So those were quite specific to art, tech, and science projects. Also, what we found, and there was definitely a common thread around sort of IP, intellectual property. So, more often than in other types of collaborative projects, IP can be a major pain point in numerous different ways. So, firstly, the collaborators could be working with a pre-existing code base that already has its own kind of layer of, probably say copyrights attached to that code base, and maybe even some kind of patent as part of that software. But then also, when you collaborate on a project, you're potentially, creating new joint IP. So there's also this question of, well, what happens to that IP in the future? Who can use that IP? Do you have to ask the other collaborators for permission? Can you commercialize that IP? How can you exploit that IP? How can you protect that IP? So all these sorts of questions that perhaps are not, as pertinent when it comes to more traditional types of creative projects, although even traditional types of creative projects do have IP as an underlying element. Here we really see many layers of different intellectual property that arise, and these question marks of who has the right to do what with that intellectual property. Another important point, I think, also with the pain points was around crediting. So there seems to be quite a lack or sort of an underdevelopment of crediting in the art field in particular, and in the art field, and also really, in the art field, in the art tech, art science field. So this question of, well, how do you credit collaborators on these types of projects? What are the standards? There are no standards. So, a point of difference could be the film industry, which has very well-established standards when it comes to crediting. I mean, everyone knows when you watch a film and you see those opening credits, like the importance of the people involved in the project, that's all very carefully negotiated well in advance of that film being seeing the light of day. Nothing like that really exists yet when it comes to the art tech and science space. So there is, that crediting is definitely something that can be worked on, can be improved. Crediting and, even royalties as well. There's no standards around who is entitled to some kind of royalties or future proceeds over a collaborative project as well. It really varies from project to project, which can make it very hard for artists and technologists and scientists to sort of really push for royalties, push for crediting if there's no kind of standards that they can point to. So plenty of pain points, but lots of findings to learn from.
Great. Maria, I'm just curious to hear from you in terms of, seeing all of this research and the findings from the side, from someone who isn't embedded in the art field. I mean, which pain points or what findings more generally do you find most interesting from kind of a developmental perspective, right? Rather than, them just being big problems that we need to solve. But, from your position, are there certain pain points or wants and needs that can be quite promising as an exploratory process as well?
Yeah, exactly, Victoria. I think there are some pain points that are very promising. Exactly, that's the spirit. Although it may seem unusual to put it this way, but it's exactly what it is. It's an opportunity, and in particular, the lack of common language. I keep being completely fascinating by this pain point, and to be honest, it's not specific to artists not understanding anything about the law. We have the same pain points in pretty much any area we work on. But what's particularly frustrating, I guess, for artists is that I suppose you could say that what artists do for a living is to express themselves, is to convey messages, and so it's particularly frustrating for them, I suppose, not to be able to have that conversation on legal issues, which can be the condition for the creation of digital art, for example. If you can't have that conversation with an art institution or with a developer, or if you have it, but if you miss a point, then it could endanger the very work of art itself. So it's of critical importance that we can solve this pain point. And what's very promising is that what we've seen in other areas is that plain language, it's a very well-known methodology. It's been there for decades, and it's extremely efficient if you combine it with co-creation and the design methodology, which is rapid prototyping and iteration. Basically, what we've seen is design sprints to solve that specific issue of lack of common language, in particular in personal data, so privacy policies, but that could be applied to many other areas. When you do that, when you co-create with all the various stakeholders, so let's imagine we put together artists, developers, scientists, art institutions together in a workshop, and we co-create that new common language based on plain language principles, but going further than just plain language, we could make it such that they would really adopt that new language more easily. And then you solve a good number of other issues that are the consequence of this lack of common language. So I really love this one in particular. I was quite amused to see the anti-contract mindset. Not a surprise, but it was quite funny to read. But unfortunately, beyond the joke almost, it's quite sad that this is 21st century, and to still have that perception that the law is not there to protect users, it's there to create billable hours. And that there's a quote around, it's all about people fighting over loopholes and not finding solutions. I think here it's not an opportunity, it's a must. This is something we must solve. There's no other way to go. And I really hope that we can do so with the Legal Lab.
Actually, on that point, and this is kind of speaking to your larger experience, Marie, I mean, what types of organizations initiate legal design projects? And so is it a field that is primarily driven by business interests, or does it require a certain level of public support, given the kind of neutral meeting ground that is necessary in order to bring parties of, different weights around the table and to have a really kind of honest conversation about pain points and to try to find a common language? Is that everything that you've been describing so far?
Well, what we're seeing currently is that many different organizations come to us with the beginning of an idea for a project, let's put it this way. It could be large private groups, it could be art galleries, it could be public entities. I would say that their common point is that their end users, so the final users of the legal documents, are just fed up with those walls of text that are pushed on them online or otherwise. I think that, after the digital revolution, there's now a very strong expectation that any sort of information should be easily accessible to everyone, and law should not be an exception. So I guess, that's the common point among all the various organizations coming to us. And I think there's no real, well, it would be great in terms of systemic impact to have public support, but businesses also find the resources to solve these issues just because that's what their business teams require. And also what's encouraging, I think, is to see the level of public awareness among governments around the power of design methodologies at large when it comes to administrative or legal issues. In the UK, you've got an amazing team in the UK Digital Services that works on making accessible all the various legal services for UK citizens. They've been doing an amazing job for at least 10 years. The French government is also applying design methodologies to make public services more actionable and more efficient and more pleasant to use. I just want to say that before we switch to questions, I guess, something we haven't touched upon yet, which is very relevant in the art area as well, is, pleasure, beauty, satisfaction. It is actually possible through the legal design methodology to turn those horrible walls of text into a pleasant UX, into a pleasant experience, into a document that you feel like reading and that fills you up with energy. All that is possible thanks to very talented designers. So I think that satisfaction, legal UX or UX, just as such, is really what we should be aiming for.
Okay, great. Thank you, Marie. So just one last question, because I think it's important to leave on that note from Alana. Can you describe some of the action steps that the report recommends, and who is best placed to lead on these? And what will the role of the Legal Lab be in this process?
Yeah, absolutely. Well, look, we had numerous action points, ranging from short to medium term action points to long-term action points. And what we did to develop these, once we had conducted the research, is we had a number of sessions with our amazing advisory panel, and we shared the preliminary report findings with them, and we sort of workshopped what these potential action points could be. And the panel really, we came up with such a broad range of interesting approaches, things from like a gamified legal language tool to a tarot card educational module. It was really the sky's the limit. And with the guidance of Marie and also Astrid, we then sort of prioritized the recommended action points into, as I mentioned, the short to medium term and the long-term action points as well. So by short to medium term, I guess we're suggesting, something that could ideally be achieved within a year. Longer term action points, ideally something that could be achieved within, 3 to 5 years, let's say. So one example of a short to medium term action point that we included in the report was this creation of like a primer statement that, or tips on collaborating with artists, which would point to some of the kind of the typical priorities that most artists have. So for example, that could be something like retaining their copyright as part of the collaborative process. By contrast, a long-term action point that we included was the development of the kind of, best practice standards, a kind of a cross-industry code that could be used by collaborators. And I should say with that idea, we were particularly inspired by the suggestion of one of our advisory panelists, also another legal designer, Sarah Raymond, who suggested a kind of a code that would have its own dispute resolution mechanism as well. Other long-term action points include, for example, looking at how we can use technology, of course, to, automate the contract building process. So kind of, maybe some kind of like choose your own adventure approach to drafting a contract. So in summary, a broad range of different action points that we want to take. And I guess what we're hoping to do as a next step now that the report is out there and available for everybody to read and take pleasure from, Marie, is to set up this kind of working groups that will work on specific action points, and we're really looking at not just working with lawyers or artists. It's really anybody who feels like they have something they want to contribute to the project. We'd be very happy to hear from you and involve you. Yeah.
Yes, absolutely.
And I think probably the best way to get in touch with us is through our email address, which you mentioned before, Victoria, which is legallab@serpentinegalleries.org.
Yeah, hopefully everyone can see it. Thank you so much, Marie and Alana. I think this is a good point to transition because we just have 10 minutes left. So could we transition to the questions, Alex?
Yes.
Please pose the questions. I will repeat the question, and then either Alana, Marie, or myself will take it.
I think this first one might be for Alana specifically.
Okay, great.
But does this work connect specifically or follow on from the Legal Labs and Alana's report focusing on NFT platforms and collaborative practices?
Is there work that focuses specifically?
Does this work connect specifically or follow on from Alana's previous report on NFT platforms and collaborative practices?
Yeah, okay. So does this work follow on or connect to your previous work, Alana, on NFTs and NFT platforms? But maybe you just need to give some factual background on the NFT side first. But I'll let you answer that question.
Yes, well, firstly, everything is connected, absolutely. So thank you for making that suggestion. So, of course, you'd have to be sleeping under a rock to not have heard of NFTs by now and how they've sort of changed the art field and many other fields over the last 6 months or so. So, I guess what was interesting actually is if you look at sort of the research timeline, at least for this Legal Lab report, is we conducted the research up until, I think it was September last year. So we closed the survey in around September, October last year. So before the massive NFT hype. And actually what was very interesting for me to look back on with the survey responses, this year was how many respondees, how many users actually mentioned NFTs. And remember, we're already focusing on people very much in this art tech space. What was very interesting for me to learn is, NFTs is really just one of the many forms of technology that artists are working with today. There are so many other forms of new tech, advanced tech, artificial intelligence, AR, XR, VR. Blockchain is just one of those, and NFTs in particular just one of those. So I want to stress that's why we didn't have a section on NFTs in our report, because really we didn't think that the kind of legal issues it raises were perhaps medium specific to NFTs per se. They really apply to art and tech and science collaborations more generally. That said, we did think that we had something to say on the matter of how NFTs support, or at least don't perhaps support as much as they perhaps might suggest, how much they support collaborations across art and tech in particular. So if you think of, for example, somebody working, an artist working with a top technologist on a creative project, one of them would have to mint the NFT, and then the one person would be considered the creator. The other person would have to kind of work out how the royalties would be factored in. A lot of the mainstream NFT platforms, though, they don't really recognize collaborative practice. I should say that has evolved in the last 6 months, at least since we initially did the NFT paper. So it's great to see that being accommodated. But it is something that's still, that singular author is very much alive and well, I think, in that NFT space. So very much a myth, the singular author, I think, as it is in the broader art, tech, and science space.
For those of you who are not aware of the paper that Alana has published on this topic specifically, you can also find it on the Legal Lab page. So I'm just pointing to it right here. Okay, thank you, Alana. Let's move on to the next question, please.
Next question's for Marie. And starting statement. I love Marie's point on making the legal experience for artists a pleasant one through UX design. How else do you think we can make the experience a pleasant one for artists hesitant or resistant to wade into contracts?
Thank you. So I will summarize. The person asking the question really loves your point around making the experience of entering into contracts or entering into some kind of legal arrangements for the artist aesthetically pleasing through UX, etc. How do you think that could work for those artists who are hesitant to use the law or deploy the law or enter into legal arrangements?
Well, to be honest, it's relatively often that we have hesitant users. Completely outside of the art sphere, we work a lot in compliance, which means anti-corruption, anti-money laundering, anti-anything, really. So obviously, that's the kind of message, don't do this, do that, that's very authoritative to start with. And most users are not, overjoyed when they come across the usual code of ethics, the usual compliance program that they're supposed to apply. So I guess we would solve it the way we usually solve this reluctance issue in most of our projects, which is user centricity and co-creation with users. Really, it's the same methodology each time. And what's really what keeps fascinating me is that it really works each time. We learn every single time during workshops with users. A couple of days ago, we were facilitating 2 workshops with teenagers, and the issue was personal data, and we, it's been an area in which we've been doing extensive research, and we already facilitated a very large number of workshops. So this must be the 10th time, and we still learned new things. So this is really how we would solve it. And of course, very talented designers, maybe not, as talented as artists, but still, it matters a lot.
Great. Do you think we have time for another question? Yeah, let's go for it.
Yeah. Is it possible to obtain general or preliminary legal advice around art tech collaborations without incurring a fee? Pro bono?
Is it possible to obtain general or preliminary legal advice around art tech collaborations without incurring a fee?
I mean, it's an interesting question. I think when you think of pro bono advice, like who traditionally offers pro bono advice? The big corporate law firms that have the resources to do that. But, the big corporate law firms, they don't generally work with artists, and they don't generally work with curators, and even technologists doing their own small independent projects for that matter. So, they bring a different kind of expertise to the table. I mean, at the same time, though, I do think there is a bit of a myth around legal fees out there. Of course, there's a huge sliding scale that can go very high up. But, there are many lawyers out there, particularly working in the arts field, that understand that artists or individuals, they're not necessarily, I should say, $1 million businesses. So, I mean, what I do think is important though, when you're looking for a lawyer, you're looking for legal advice, especially when you have such a kind of specialized area of practice in this art, tech, science overlapping fields, is really to find a lawyer, to find an advisor that you can build a long-term relationship with. I can't overemphasize how important that is and how different that is to getting singular one-off pro bono advice. Really, when I think of my own legal practice and my own relationships with clients, the best relationships, the best advice I can give is when I know my client really well. So don't be afraid to ask for legal advice. Don't be afraid to ask how much and a lawyer's fees would be. I think, especially in this art space, and I should say one of our shorter term action points is to develop a quite engaging kind of a user directory on specialist lawyers in the space. I think there's lots of potential for really interesting relationships to develop between creatives and lawyers. Yeah.
But perhaps also outside of these relationships, I think there's a lot of more kind of basic foundational knowledge about these collaborations that can be made accessible publicly. And perhaps a lot of these preliminary questions can be answered through the existence of various resources that, we'll list as our short-term to medium-term action points, whether it's the directory, but also, let's say, how to guide a negotiation and managing pain points, for example. So it does seem to me that there's a lot of work to be done to support the sort of self-education that is necessary for artists and creative practitioners to feel more empowered by using the law as one of their kind of tools within their kind of wider portfolio of resources and possibilities. And that's really what the Legal Lab is kind of trying to support, the development of these sort of foundational basic tools, as well as hopefully kind of innovation at the side of, contract negotiation and just general kind of knowledge around art, tech, and science collaborations. So I think at this stage, we'll close it out. So thank you so much. Thank you for joining. Thank you for speaking. Alex, thank you for fielding the questions. I realize there may be many more questions, so please don't hesitate to write to us. And also, if you have ideas that might not be directly related, but you want us to know about them, please do write to us. We always welcome feedback. So thank you so much, and hopefully speak to you soon.